This is a good question, and it involves due process hearings. It involves some of the states engaging in something called summary judgments, and that is something that is determined prior to an actual hearing. It's supposed to be based upon the merits of whatever is submitted at the time, meaning that there's an analysis, of presented documentation or evidence, and the whatever submitted documentation is so overwhelming as to create sort of a determination that a judgment is warranted. Okay, and so that's a summary judgment. It's a decision on the case, on the merits of the case, before any evidence is, meaning any witnesses are questioned or additional evidence is submitted. All right, it exists in many court proceedings, but does it exist within special education proceedings? And that's the question. And I think it's compelling, and so it's a very good question. So let me read it. Please publish the recent opinion. And I'm going to do that, and I'm going to link it in my response. Of the OSEP regarding summary judgment motions and other common questions. In our due process journey, we endured 3 summary judgment motions because the ALJ, administrative law judge, and both lawyers had no idea what they were doing. My husband and I were the ones saying summary judgment wasn't recognized under IDEA once the complaint was deemed sufficient. In the appeal process by the district, it is still an issue. Okay. So let's review the policy. First of all, any of you that don't know, the name Zirkel, Zirkel. If you don't know it, Google it, guys. He is a professor that has an expertise in this area of special education law, and he does a lot of training for our special education judges across the country. And so he is sort of he is one of the, I don't know if you would call it one of the pulsating brains of special education law, but he holds a lot of respect, and I think it's warranted. I don't mind him, but if you Google, you'll end up finding a lot of information from Perry. His first name is Perry Zirkel, with regards to opinion briefs and viewpoints with regards to special education law. And I'm talking due process hearings and how they should be taken and how things should be interpreted. So he's a well of knowledge. So with regards to these opinion letters, you can submit a letter to, let's say, Office of Special Education Programs, OSEP, or to OCR, to the federal government, and pose a question with regards to how things should be interpreted, okay? And Zirkel has done a lot of that over the years. And so what they end up doing is OSEP will end up rendering a decision about how things should be interpreted. And then it becomes an OSEP decision. And that's why OSEP decisions, if you are familiar with them or if you read enough of them, they are titled Letter to So-and-so. So, meaning that they're a response to whoever crafted the question. And it could be anybody. Most of the time it is to school administrators. And in this case, it was a response letter to Zirkel's question. But what I found compelling is, number one, with regards to due process complaints and due process hearings. And it was talking about a parent, not meaning one not represented by an attorney, because you can act as your own attorney in a due process case. Now, within those requirements, there's and I'm not saying the standard's different, but the expectation on myself as an attorney on being able to file a good complaint. Obviously, if I'm not filing a good complaint, then I shouldn't be in this area of law. All right, but parents have sort of a diminished standard, a minimal standard of what must be inside a due process complaint in order for it to survive that initial review or that initial analysis. And that is scrutiny that all the components need to be there, meaning that you have to designate the school, you have to have your address, it has to be verified that there's jurisdiction, that you do live, in fact, in the district that you're complaining about, that you are outlining or you're laying out what the issues are, and that those issues speak to one of the justifications for filing a complaint. One of which is that they denied my child a FAPE, okay, which is fairly broad. The other ones are identification, eligibility, least restrictive environment, and then also jurisdiction. Those kind of things are also in there. But the big one is the catch-all is sort of, they denied my child a right to a FAPE. So as long as it hits one of those, then it should move on to the next step. And the next step is, what are you asking for with regards to relief? What are the solutions? And so the initial question in this is that what happens to a parent's failure to provide a proposed resolution of the problem in the due process complaint as required by 34 CFR 300? And does it restrict the hearing officer's ability to order prospective relief if the parent fails to designate any? And OSEP responds in a very, very, I think, reasonable aspect where they say, look, it says that the school board has 15 days. I think it's what it is. Yeah, 15 days after the complaint is filed. 15 days to review the complaint and respond with an answer, which is normal in any court proceeding. You sit there and you file something, and the other side gets a certain amount of time to provide an answer to your complaint. And in that answer, the school can sit there and say, look, they did not explain X, Y, and Z. Their address is wrong. And you would sit there and go, what the hell? Guys, I can tell you it happens so many times, even in the cases that we have, to where we end up finding out, well, the parent gives us their address, and then for whatever reason, the school is coming back saying that it's outside their boundaries and that they have so therefore jurisdiction becomes an issue. It happens. So those things are scrutinized all the way down. Where the parents live, are they even zoned for our school? And you sit there and you go, well, my kid's been attending there for 3 years. Well, somebody could have dropped the ball and not scrutinized your address comparative to you enrolling them. It happens. And I'm just telling you, at that point, they sit there and they should never have been in this district in the first place. And yes, that's a technicality, but it throws out your complaint. Sort of. I'm not going to get into that, but I don't think it does, because we went ahead with it doesn't matter. At that point, the school would still, they've been serving the child, therefore the child's still entitled to compensatory. They may not be able to attend the school moving forward, but it doesn't rewind and erase the mistakes that the school made. But then they'll look at the substance of the complaint. What are they complaining about? Does it meet one of those criteria? And then the last area that we discussed is what is the relief? What is the resolution? And that's the point that they're raising in this question. Well, what if they don't know? And what OSEP is saying is that was your opportunity. You had 15 days to sit there and say that it didn't meet the sufficiency standard. And if the school fails to file an answer, which many schools fail to file an answer, they just don't. In the cases that we do, we'll file a complaint. Many school systems will not file an answer. Okay, well, it just means that we move on to the next step. Doesn't mean that somehow I win because they failed to file an answer. It just helps me out. It's not like other courts. It's not like other areas of law. Okay, guys, there's a little bit more flexibility in this one, to where it's still in the administrative realm, to where it's sort of a precursor to federal court. Okay, so there's more flexibility down here. This is more of a collection of the record. It's more of a combination of the storytelling, to where if necessity deems, then the federal court will look at it. But most of the time, this is handled on an administrative level as to not clog up the federal court, okay? So that's why there's a little bit more flexibility down here. And so what OSEP is saying on with regards to that is that if they file their answer and they claim that there isn't sufficiency, then the hearing officer or the ALJ will go back to the parent and say, look, you need to add more to it. You need to correct your defects with regards to either substance or what you want with regards to relief. But let's say that they don't, and that was the answer here. Let's say that they don't file an answer, and the case is deemed sufficient, and it moves forward. And then at the end, after a hearing is done, and it's left up to the hearing officer, the school can't come back and go, well, they didn't put any relief in there. Guys, I have been through many hearings over the years, and as I tell parents, what I end up putting out there with regards to relief, what we're seeking to correct the problems, it's my wish list. But a hearing officer does not have to follow my wish list at any point. And I'm quite cognizant of that, and they haven't done it. They'll take parts of it, they'll piecemeal it, but they will not give me everything that I want. That's why I work hard to avoid a due process hearing. We file a lot of complaints, but I will work hard to avoid going to a hearing. Why is that? Well, because the minute I go to a hearing, I absolutely remove all of the control that I have to try to formulate a solution that we are in control of, that we can sit there and help work with the school to define in the form of a settlement agreement. If we go to a hearing, yeah, I'm going to do my damnedest and I'm going to put on a show and we're likely going to win. At the same time, I don't have any control about what we get because now that has been handed over to a hearing officer and they do not see things the same way James Galini sees things. They do not believe that we need to seek outside help to raise the standard of knowledge of an expertise of the people working within the schools. So many times the solutions are, hey, school system, you need to train your staff and you need to do this. Even though I won, it doesn't mean my client won because the hearing officer is awarding something that it sort of looks like what I asked for, but not really. Because what I'm asking for is bringing in outside professionals to help to raise the bar of knowledge. Now, I feel passionately about that. Why do I? Well, because if the school knew what they were doing, the parent wouldn't have come to me. If the school had the expertise that they needed, the parent wouldn't have had these issues. It would have already been done. And so when the school says, oh, but James, we have a behavior analyst or we have a dyslexic trained teacher, I'm like, then why the hell didn't you use them for this kid? What were you holding out? Did you lie to the parent? Did you sit there and tell them that you didn't have this person working with them? Because if you have these resources, then why didn't you put it into action for this family? And I feel strongly about that. And I don't like giving schools some second opportunity when they had the first one to do the right thing and chose not to do it, especially if they employ professionals that could do those things. You see what I'm saying? So losing that ability to fashion the end result that as in the way that it needs to, and getting a negotiated agreement with the district, yeah, I mean, we put on the pomp and circumstance and we can win the case, but then you lose the end result to the hearing officer. Now, how does this circle back to the Zerkel response? Because the Zerkel response at the end, OSEP says, if you didn't complain about the sufficiency, it rests back in the hearing officer's position. Well, I already knew that because I've been doing that for years. It doesn't matter if I put X, Y, and Z in there. At the end of the day, it is up to the hearing officer to determine equitable relief. That is the legal standard, equitable relief. And that's what the hearing officer does. Doesn't mean that you don't put in, this is what I think will resolve this issue. The hearing officer will sort of use that as a template and a basis. but most of them will go off of the proverbial reservation and fashion equitable relief in a way that they believe will serve the student. Most of the time, they will tell the school to do it themselves. I don't trust that. I think the schools need help. I think that a better use of public dollars is to go out and acknowledge that we don't know what we're doing in every situation. I'm not talking about all situations. I'm talking about there are situations to where schools need outside professional expertise that they don't currently have. And I'm asking to bring them in order to raise the standard. Once the teachers have been trained, then at that point, no, you can fish, but you need to be taught how to fish. And that's where I come in and say, we need to teach you how to fish in these areas, in that area, in this one. And then once they're there, it's a gift that keeps giving, man. You have some very, very great teaching professionals, great aides, great administrators. And then your advocacy for your child ended up impacting multiple children. And those parents had no idea that you were the one advocating. You were the one carrying the heavy water. You were the one stressing out and losing sleep. But they're benefiting because you raised the low level. Not only that, is you made the teacher and the aide's life so much easier and so much better. It is the silent, thankless experience of being a parent that throws themselves out there and exposes themselves to all of this. You know, you do more good than you know you do. It ends up impacting so many additional families. Okay, so what about that second question, summary judgment? Summary judgment, they tried to do that in Alabama years ago, and I don't agree with summary judgment. If you end up going to a hearing, guys, it's not like you can't stipulate on the record, which is sort of the same thing. You can stipulate on the record that there's no longer an issue in X, Y, and Z area because you got those things worked out. But, you know, you can't get around the fact that just the strict reading of the law, you have a right to put on evidence. You have a right as a parent to question witnesses, X, Y, and Z. And summary judgment denies you that right. And I mean, even if some of the times, you know, the summary judgments rule on the part of parents, at the same time, it denies you your right to question witnesses and put on evidence. And that's just what the law says. So summary judgment shouldn't be allowed. But this is the thing, is even on appeal, it's going to get to a federal judge somewhere that should understand this. And if they don't, I mean, look, you know, in Drew F., for example, ended up having to go to the Supreme Court. And the Supreme Court disagreed with everybody along the chain. So, you know, just because a judge rules on something doesn't make that judge right. It just makes that judge human.